Welcome back to Part 3 of the Kelso Report's California Supreme Court review of the 2010-2011 term. In Part 3 here, we're going to be covering cases dealing with criminal law. We begin with a case involving probation conditions. The California Supreme Court has previously held that a prison sentence imposed after plea bargain may not be based on the facts of a dismissed charge, unless the defendant consents or a transactional relationship exists between the admitted charge and the dismissed charge. That was the holding in People v. Harvey, a 1979 decision. This year, in People v. Martin, the court extended that holding to the imposition of probation conditions. The facts were simple. Defendant's girlfriend called police to their apartment after defendant allegedly punched her in the face and choked her, and then fled the scene. Police arrived, noticed that there was redness and swelling on her nose and cheek, and not being able to find the defendant in the neighborhood, left. Later that same day, defendant's girlfriend called police to say that he was back. Officers quickly arrived and saw the defendant going up a staircase towards the apartment. When ordered to stop, he started running up the stairs with the police in pursuit. As defendant entered the apartment's front door, one of the officers put his foot in the door to keep it open, and the defendant slammed the door shut on the officer's foot and ankle, injuring him. Defendant then fled the apartment but was captured a little later by police, but not before putting up another fight. Defendant was charged with felony resisting an officer by the use of force or violence and a misdemeanor of corporal injury to a cohabitant. The prosecution negotiated a plea to drop the misdemeanor, plead guilty to the felony, and be placed on probation, which would include service of 120 days in county jail. The Superior Court made it clear that it also wanted to impose probation conditions related to the domestic violence charge, such as requiring him to complete a 52-week domestic violence batterers program, to pay $400 to a domestic violence fund, and to pay $400 to a battered women's shelter. Although the defendant initially objected, he decided to take the plea and the probation conditions, since the court indicated it would otherwise not accept the plea bargain. The Court of Appeal held that the additional probation conditions were lawful because, in its view, the Supreme Court's decision in People v. Harvey applied only to increases in prison terms and did not extend to probation conditions. The Supreme Court disagreed. For the court, the limitation in Harvey came from the fundamental character of a plea bargain as an agreement among the prosecutor, defense, and the court. Implicit in that agreement, according to the court, is the understanding that the facts of a dismissed charge, not related to the facts of the charge to which the defendant entered a plea, may not be used against him without his consent. In essence, the Harvey court held that a deal is a deal. Given this understanding, there was no basis for distinguishing Harvey in the probation context, and the Harvey rule therefore applies to probation conditions. On the particular facts presented to the court, it held that the defendant actually had consented to the domestic violence probation conditions. The trial court told defense counsel he would reject the plea unless there was an agreement to the domestic violence probation conditions, and after conferring with his client, counsel told the court, based on the court's indicated sentence and probation terms, he's willing to accept those probation terms. The Supreme Court made it clear in a concluding footnote that it was not addressing at all the procedural questions that obviously would now arise in the future regarding preservation or forfeiture of appellate issues. Next, one of the criticisms of California's criminal procedure is that post-conviction reviews seem to go on forever, particularly in capital cases. In 2002, the legislature added in Penal Code Section 1054.9 another post-conviction process for the benefit of inmates sentenced to life without possibility of parole and inmates sentenced to death. These inmates may obtain post-conviction discovery from the prosecution of any materials that the defendant would have been entitled to receive at the time of trial, upon a showing that good faith efforts to obtain those materials from trial counsel were unsuccessful. The issue before the Supreme Court in Catlin v. Superior Court was whether a motion under Section 1054.9 could be denied on the grounds that it was untimely. Although Section 1054.9 does not contain any specific timeliness requirements, the trial court and Court of Appeal had concluded that the defendant's 4-year delay after the enactment of Section 1054.9 in seeking discovery made the motion untimely as a matter of equitable principles. The Supreme Court reversed. Although the Supreme Court itself had suggested previously in a casual footnote that Section 1054.9 was subject to some type of timeliness requirement, when the court in Catlin actually consulted the legislative history carefully, it became clear that the legislature was specifically aware of the concern about timeliness and had decided not to add any timeliness limitation to the language. In light of this legislative history, the court was constrained to hold that there is no timeliness limitation to a motion under Section 1054.9. The court pointedly noted near the conclusion of its opinion that it did not have to consider in this case problems involving successive or repeated discovery motions or allegations that a motion was interposed solely for purposes of delay. In addition, the court suggests that its determination about the timeliness of a writ of habeas corpus is unlikely to be affected by the timing of a motion for discovery, so there will be very little incentive to delay seeking discovery. It will be very interesting to watch the California Supreme Court and ultimately the federal courts try to deal with the issues that Section 1054.9 is almost surely going to raise. At the very least, notwithstanding the court's explanation, there is now one more post-conviction process that common sense suggests will delay implementation of the death penalty. Next, we turn to search and seizure in a game warden context. The California Supreme Court held in People v. Maquillo that a game warden who reasonably believes that a person has recently been fishing or hunting, but lacks reasonable suspicion that the person has violated an applicable fish or game statute or regulation, may nevertheless stop a vehicle in which the person is riding to demand the person display all fish or game the person has caught or taken. The issue arose in a case where the game warden saw the defendant fishing off a bridge, but couldn't be sure whether the defendant had caught a spiny lobster, which was out of season. The warden stopped the defendant's car several blocks away from the bridge and asked the defendant if he had any fish or lobsters in the car. When the defendant denied having any, the game warden looked in the car, saw a black bag on the floor, opened the bag, and discovered a spiny lobster. The defendant was charged with a misdemeanor, but the trial court suppressed the evidence and the Court of Appeals affirmed. The California Supreme Court, in an opinion by our new Chief Justice, reversed under the administrative search rationale and sent the case back for further proceedings. As the court explained, the state interest underlying a stop and demand pursuant to fish and game statutes is quite distinct from the state's ordinary interest in the enforcement of its criminal law. And the limited category of persons affected by the procedure, anglers and hunters, are individuals who have chosen to engage in a heavily regulated activity that reduces their reasonable expectation of privacy with regard to the type of intrusion at issue. In other words, the fish and game warden can indeed go on a fishing expedition. Finally, if courts were classrooms for philosophical discourse, we could spend an entire semester on the question of whether a person can become something that they already are. For example, if you already are a lawyer, can you become a lawyer? But courts are not classes for philosophy, and statutory interpretation is not a philosopher's game. In People v. Zambia, the California Supreme Court had to interpret Penal Code Section 266I-A2, which defines pandering as encouraging, quote, another person to become a prostitute, close quote. The defendant was convicted of pandering when he tried to encourage an undercover police officer who was impersonating a prostitute to come work for him. The defendant argued that Subdivision A2 does not apply when the target is already a prostitute or an undercover police officer acting as one. The defendant asked, how can I encourage someone who is already a prostitute or who is acting as a prostitute to become a prostitute? And how can I have the intention of making another become a prostitute if I believe they already are a prostitute? In short, how can something become that which it already is? Well, if you wanted to go with the pure plain meaning of the phrase, to become a prostitute, then I think you would vote with the two dissenting justices, Kennard and Werdiger, since the word to become connotes a change from one state to another. But the five-justice majority worked its way around the plain meaning by the overall context of the rest of the statute, which criminalized other types of pandering-related activities without drawing any distinction between whether the other person was already a prostitute or not. The court also resorted to 40-year-old legislative history, suggesting that the statute should be read broadly to cover all pandering-related conduct, and the court relied upon a string of intermediate appellate decisions over the years, to which the legislature arguably acquiesced by amending the statute multiple times without overruling those cases. For my money, the legislative acquiescence argument is the majority's best bet here, because the dissenters win on the plain meaning of the statute. This is another example of how to work beyond the plain meaning of words in a statute. Either that, or the majority has adopted Bob Dylan's perspective, we have never arrived, we are in a constant state of becoming. And that's it for this Kelso Report review of the California Supreme Court's 2010-2011 term. Hope you've enjoyed the report. Have a great day in the law.